These are official court proceedings. These are public proceedings. I need all videos open, please. Because these are official court proceedings and public proceedings, we are streaming live on YouTube. Good to see all the beautiful faces. Hope everyone's starting with a great morning. We are streaming live on YouTube. The YouTube link, Zoom link, and password are available on the court's webpage. Because these are official court proceedings, you must adhere to and abide by professional courtroom decorum. So surprisingly enough, you may not be driving, drinking, smoking, lying in bed. You can't be at the dentist's office, can't be at the doctor's office, can't be driving down 285, fixing the kids' breakfast, picking them up, dropping them off. Find a place where you're comfortable, be seated, and be still. Anyone recognizes the gentleman whose screen name says Galaxy A71 5G? If that is your client or your witness, that party does not have any audio. I've tried chatting with that party and have not received a response. So if anyone recognizes him as a client or a
Yes,
witness,
it's me,
what's your name?
Ronald.
Why do you have two devices open?
Sorry.
Close one of them, please.
Okay.
This is Division 10 with the Honorable Tangela Barrie presiding.
Good morning, everyone. My name is Judge Tangela Barrie. I'm the judge for Division 10. This is our civil motions calendar. We have 4 or 5 cases on the calendar this morning. I'm going to call the calendar. Please let me know if you are ready to proceed, how much time you're requesting of the court to hear your side of the case, only your side of the case. I'm going to add the time together, and then I'll let you know how I'm going to hear the case, okay? Let's see. My first, Mr. Rex Williams, the reason why I took that break was that this motion that you filed should not have been on a motions calendar to be heard. Either the court is going to grant it or deny it. And on motions like this, generally I would deny this motion. I had a hearing. You guys were not present. You need to start your filing over because it's been dismissed. And I know your position is you got confused about the date. That might be, but I've already had the hearing. It's dismissed, but you can, of course, it's not without prejudice. The divorce, you just refile it. And that's generally how the court would handle that matter. I wouldn't have a hearing for you to tell me why you missed the court date. That would be a waste of the court's time because I have so many other matters to resolve. So if you missed it and it's not the court's fault, then I just tell you to refile it.
So can you just sign it up or something? She told me she never requested hearing. And I don't know how come we have to have an hearing. We already settled it between us.
Yes, sir. I'm not, like I said, I scheduled a hearing. I scheduled a date. You guys missed. Whether you missed because you didn't think you needed a hearing or she didn't tell you about the hearing, those are just things I cannot deal with. It's just too much for the court to try to get into the weeds of why you missed the hearing that particularly can just be placed back on the calendar. So I can't spend any more time on this one. Okay, Mr. Rex Williams, you have to refile it.
Okay, thank you, Judge.
All right, take care. Okay, I got your 4 points. Go ahead, you may proceed.
Yes, Your Honor. So you've correctly perceived that I have 4 basic arguments. So the brief does a pretty good job elaborating those. I'm going to hit the high points and I have a little bit to add, but those are my primary responses here. So the first point involves that Mr. Monroe has an unwritten contingency fee contract here, which is illegal under Georgia law. Georgia Rule of Professional Conduct 1.5 says that for a contingent fee agreement, it has to be in writing and there have to be certain other, points in that writing. So there's nothing like that here. And with our brief, we submitted the discovery responses of the plaintiff, which flat out states there's no fee agreement here. So the problem with that, with providing for fees in this case, is that it involves the court in enforcing an illegal contract. The courts have said under OCGA 1382 that the courts are not going to get involved when an illegal contract is involved. So a contract that's against public policy of the law cannot be enforced. And that's what's going on here. So there are cases in Georgia where the courts refuse to enforce agreements like that and deny attorney's fees award. The leading case is Nelson and Hill PA v. Wood. It's 245 Georgia Appeals 60. There was an unwritten contingent fee agreement, and the Court of Appeals found that the fee agreement was unenforceable because it violates public policy. There are other similar types of cases where, the fee splitting legal or something along those lines. And we cited at least one of those other cases. I think the case I didn't cite is Brandon v. Newman, 243 Georgia Appeals 183. That's another fee splitting case with a non-lawyer, and the court refused to enforce that, refused to apply that. So that's what we've got here. We've got a court in Arizona, for example, the Arizona Supreme Court saying an attorney wishing to be compensated for his professional services on a contingency basis must have a written fee agreement signed by the client. In the absence of a written contingent fee agreement, an attorney should anticipate that work done in violation of Rule 1.5C is being undertaken without any meaningful expectation of compensation. Your Honor, I lost the picture of you.
You didn't. When I drink or do something, I turn it off.
Okay, I just want to make sure that we're communicating clearly.
We are.
You can do whatever you want, but I want to make sure we're not getting cut off here. So that's the basic point number one. There's no written fee agreement here, and Mr. Monroe in the first hearing, testified and stated in his place under questioning that there is no contingent fee agreement. There's no written fee agreement here, which is confirmed by the plaintiff's discovery responses. So if you're going to award a fees, that involves the court in enforcing an illegal fees contract, because the fees contract that Mr. Monroe has is that he gets all the fees that the court awards. That's what he says his agreement is with the plaintiff. Of course, so that's the basic gist of the first argument. The second argument is that the plaintiff cannot recover fees under this statute 1611-129J that are unrelated to obtaining mandamus relief. So that's basically a statutory construction type of argument, and here are the parameters of that argument. One is that any statute that provides for the award of attorney's fees is in derogation of the common law, and it must be strictly construed against the award of such damages. So that's Kemp v. Kemp, 337 Georgia Appeals 627 at page 632. So the statute has to be strictly construed against finding fees. Additionally, we're going to deal with appellate fees, and the rule on that is a determination whether appellate fees are authorized by statute turns on the language of the statute permitting the recovery of attorney's fees. So that's Cotter v. Cotter, 286 Georgia 16. So we have to look at the statute and figure out whether it provides for appellate fees. So turning to this statute, this is 1611-129J, as in Juliet, and I know you probably don't have that in front of you, but I'm going to read the basic critical provisions here. So it provides, in part, the applicant who's denied a license may bring an action in mandamus or other legal proceeding in order to obtain a license, temporary renewal license, or renewal license. And it goes on to provide, again, that the applicant, if they're denied, they can bring an action in mandamus or other legal proceeding in order to obtain the license. And then the last sentence says this: if such applicant is the prevailing party, he or she shall be entitled to recover his or her costs in such action, including reasonable attorney's fees. So my point about statutory construction is that this statute provides for attorney's fees and expenses for obtaining mandamus, and that alone. And it doesn't say anything about appellate fees either. So what we've got here is the plaintiff claiming 9 hours are compensable for probate court proceedings, and that's not right. That's not provided for in the statute. And we've got the plaintiff asking for another $14,000 and change for appellate proceedings, which is also not compensable. So the statute doesn't say anything about appellate proceedings, and the court is fully aware that by the time we ever did anything about an appeal, the plaintiff had already obtained mandamus relief. Mandamus relief was granted off the table. That was not what the appeal was about. The appeal was about whether, attorney's fees are awardable and about the constitutionality of this statute. So OCGA 1611-129J does not provide for attorney's fees for litigating an appeal about those matters, about the constitutionality of the statute and about, etc. The subject matter of the appeal is not compensable under the statute. It provides for attorney's fees for obtaining mandamus relief, period. That's what the statute says, and that's all that can be recovered here, if anything. I note also that in this action, the plaintiff sought more than mandamus relief. He filed, for example, Second Amendment type of arguments and claims. And that, I don't think he prevailed on that. I don't know that the court really addressed that in any of the orders, but that's not compensable either. And I don't know that that's been segregated and cut off of the fees that the plaintiff is trying to recover here. But that's the plaintiff's burden to segregate things that are not compensable from whatever is compensable. And so I leave that to Mr. Monroe to give that a shot. But the rule is that if the plaintiff doesn't segregate, then generally I think the court can do whatever is reasonable, but that includes knocking off the whole award. So, Judge, you're frozen. Can you hear me?
Oh, no, I'm not frozen.
You were frozen on my screen. I'm sorry.
Okay.
Again, sometimes these Zoom things are glitchy, and I just want to make sure that we're communicating clearly.
I got you, Mr. Waymeyer.
Fair enough. Okay, I have two more points, and I'm going to be quick. Let's talk about Mr. Monroe's rate and how it's changed. Mr. Monroe has never billed his client at all. He said that in the first hearing. His rates are just plain old what he makes up, frankly, and that's not reasonable. The court is the expert at least about what a reasonable hourly rate is, and it's not just what Mr. Monroe says. No client was ever billed on this. No client ever agreed to any kind of rate. In fact, Mr. Monroe didn't even tell his client when the rates allegedly went up. So I'll just tell the court my rate for this case is $195 an hour. That's a reasonable rate for a case of this sort. I've been practicing law for 20 years. Mr. Monroe, I think, has been doing it longer, but I don't know that the difference in time frame really matters a lot so far as both lawyers being able to handle this case and present arguments effectively. The discovery responses for the plaintiff indicate that the rate that Mr. Monroe was going to claim was $300 per hour, and he never amended that. And I just note that the statute provides for, quote, reasonable attorney's fees. So I think part of that, part of the consideration for that goes into what is reasonable for this particular action. So I have a couple of points on that. One is nobody in their right mind no client would spend tens of thousands of dollars on a gun license. That's just not reasonable at all. If a fee-paying client, went to Mr. Monroe and said, "Hey, Mr. Monroe, I want you to represent me," and Mr. Monroe said it's going to cost you $20,000 to $30,000, everybody in their right mind would say, "No, I don't want a gun license that bad. That's not reasonable." So I think that's one consideration in this type of case. The other type of consideration is what happened in the probate court. So let me just outline that real briefly. Judge Cuthbert was concerned about Mr. Roberts' history, his arrest history, which was not, some of the GCIC information was incomplete. The judge couldn't figure out what happened with some of these charges, and it gave him concern. And so what happened is the judge said to Mr. Roberts, "Please show me what happened and tell me what happened with these particular arrests. What's going on here? Satisfy my concerns, and we probably won't have a problem. We'll see." What the plaintiff did was produce nothing about that, explain nothing about that, came into court with Judge Roberts, had a hearing, and said, "Oh, we don't have to tell you anything about that. We know that you wanted us to bring records and tell us that, but we don't have to. Forget about that. Not going to do it." And so Judge Cuthbert denied the license. That's what happened here. So it's something of a provoked response. When a judge tells you, "Hey, I just need to see some documentation. I need to see this. I need, tell me about this, alleviate my concerns," and then the party shows up and does none of that, what do you really expect to happen? And is it reasonable then to file an action and, you know, run up $20,000, $30,000 in attorney's fees on something like that when you provoked the whole situation and you could have prevented it? I say no, that's not reasonable at all. And that should be factored into the court's consideration. Lastly, this is my last point, point 4. The plaintiff assumes, Mr. Monroe assumes, that the court should undertake what the federal courts call a lodestar calculation, which is you find whatever hourly rate, you know, makes sense, and then you multiply it by the number of hours that are compensable. That's the lodestar method, and whatever number you get there is the reasonable hourly rate. Well, Georgia courts have said that's not how the Georgia courts find what a reasonable hourly rate is. In fact, the one case that's considered that has rejected it. So here is Cajun Contractors v. Peachtree Property Sub LLC. It's 360 Georgia Appeals 390. Georgia courts have not adopted the lodestar method in the calculation of attorney's fees. That's Judge, I might mispronounce her name, and I'm sorry to her, but Gobeil in a concurrence. Judge McFadden in a dissent said this: the only Georgia case I have found that addresses the lodestar method declines to adopt it. And he cited a Friedrich case. It's 247 Georgia Appeals 706 to 707. So I submit to you that the methodology of finding it a reasonable attorney's fee here is not the lodestar method. It's probably something more like, what is reasonable for a fee-paying client to spend on a gun license litigation, and only the mandamus portion of the gun license litigation, not all the other extra baggage that was added to this particular case. Those are my arguments, Your Honor. I appreciate your time.
All right, Mr. Monroe, do you have a response?
Yes, thank you, Your Honor. I'll try to go in the same order that Mr. Waymeyer did for your note taking purposes. First of all, I did not have a contingent fee agreement with my client, Mr. Roberts. A contingent fee is one where the attorney would be entitled to usually some percentage of a damages award. That's not the arrangement I have with Mr. Roberts. In fact, Mr. Waymeyer knows that I do have a written agreement with Mr. Roberts because I provided it to Mr. Waymeyer after our last hearing. My agreement with Mr. Roberts is that he paid me $1,000, and the agreement was that if there were a fee award, that I would be entitled to the fee award. But there's not a contingent fee arrangement because we didn't sue for damages, and I'm not entitled to a portion of any damages if any damages were awarded. So it's not a contingent fee agreement. Even if it were, it was written, and it wasn't contingent on anything. And it's not really necessary to enforce a contingent fee agreement because we're talking about as between whether you'd enforce it or not would be as between the client and the attorney. Here, if there were a contingent fee agreement that wouldn't be enforceable, that would just mean the client gets the fees, and he wouldn't have to give them to me. The second point, fees related to mandamus only. I guess what Mr. Waymeyer is saying is that the fees from the probate court wouldn't be compensable. Well, I mean, the hearing was necessary before the probate judge in order to get to the mandamus portion. But if you did want to discount it, there were 8.2 hours spent in the probate work, and that was when my rate was $300. So that would be what, $2,460, I think, that would be reduced. As for whether the appellate fees are awardable or not, you can't stop at the trial court level. You have to either enforce appeals against you, or you have to launch appeals if you lose, and that's what we did here. If the rule were that anything that happens at the trial court you can get fees for, but if you have to appeal it or you get appealed, that's too bad. There isn't a rule like that, Your Honor. I think Mr. Waymeyer mentioned there was a 2A claim, a Second Amendment claim. There was. The court's order in this case, which wasn't appealed, didn't say what the outcome under the Second Amendment claim was. But when a plaintiff brings a case, he lists all of the potential legal theories under which he can prevail. If the court doesn't necessarily select one, as happened in this case, it's not the plaintiff's burden to show to only bring one claim with one legal theory. It's typical to bring all the possible legal theories that you have, which is what we did in this case, and we did prevail in the case. So a reduction based on a potential of not prevailing under a claim it wouldn't be appropriate when the court basically awarded all the relief that we sought, and that was in order to issue the weapons carry license. As for rates, my rates are not whatever I make up. I review my rates every March every year. They stayed the same for many, many years during the COVID period, is unfortunately when we're talking about here. I did have a couple of rate increases. The rates that I put in my fee applications are the rates that I'm charging clients that pay on my rates, and I do have several clients that do pay my rates instead of a flat fee arrangement or the kind of arrangement that I had in this case. I know Mr. Waymeyer said his rate is $195. I think it's no secret that insurance defense attorneys have low rates. That's just the nature of the beast. But attorneys that are not dependent on insurance companies paying them have higher rates, and that's the case with me. I've been practicing for over 30 years. I believe I've brought more cases like this than any other attorney in Georgia, and we had a successful case, and then we had to appeal to the Supreme Court, and we won there too. So that ought to count for something. Mr. Waymeyer said nobody in his right mind would spend tens of thousands of dollars on a case like this. That might be an appealing argument, but it's not true, because I have had a client pay me tens of thousands of dollars on a case like this, and in that case, we actually got a fee award and he got reimbursed. But I've had a client do that. Mr. Waymeyer talked about the hearing at the probate before the probate judge. I don't think he characterized it exactly correctly. I represented Mr. Roberts before the probate judge. We went there. We did not have any of the documents that the probate judge had requested. It's not that we refused to provide them. We didn't have them. But I called my client as a witness. He testified about every single arrest that was on his record and what happened in them and what the outcome was, that he had never been prosecuted or convicted for any of them. And the probate judge was free to ask questions of Mr. Roberts, cross-examine him, whatever he wanted to do, and he chose not to. So we presented plenty of evidence on what happened in the cases, just no documentation because we didn't have any. Last point, the lodestar amount. I think it's true that the appellate courts have not officially adopted the lodestar amount in Georgia, but they haven't adopted necessarily a different method either. And there's nothing wrong with the lodestar method. Mr. Waymeyer hasn't really suggested another method that would be a suitable substitute other than well, whatever you think it's worth kind of deal. And that's not how it works. I mean, there has to be some methodology to come up with a fee award, and the lodestar amount, I think, is as good as any, especially when no other methodology has been suggested, Your Honor.
With regard to the lodestar, the concept behind that is that there were other matters that were being argued, i.e. the Second Amendment, and your concern is that it would be difficult to kind of separate the hours spent on that versus the hours spent on the issue of the mandamus and the attorney's fees.
Well, that's true. And also the Second Amendment claim just sought basically the same relief, the issue, basically an injunction to issue the weapons carry license. So that was effectively the relief that was obtained. So, I mean, the court's order didn't say this legal claim prevails, this one doesn't. It just, basically said we win and ordered the probate judge to issue the weapons carry license. So you could say we prevailed on all of them. But my point is, when you bring a case and you've got multiple legal theories, just because one of them prevails and the other one doesn't, the court didn't explicitly reject any of them. I don't think. I think the case law is that plaintiff's entitled to attorney's fees on all of his viable legal claims. Okay.
And then the last issue he brought up was with regard to the appellate fees. His position was that if you read the statute, it says mandamus, and the mandamus issue had already been resolved. That is, that he had the right to get the gun permit. So when you went to the Court of Appeals, it was simply about the attorney's fees, but the mandamus matter had been resolved. And so appellate fees should not be considered. What's your response to that?
Well, the statute says that the prevailing plaintiff is entitled to an award of fees. It doesn't say, at the trial court work, it doesn't say the appellate court work. It just says the prevailing plaintiff. And we hadn't finished prevailing yet at that point because the court denied fees. So we got the mandamus, but didn't get the fees yet. So we were obligated to appeal the court's denial of fees. And it's only proper that the time spent achieving that should be compensable.
All right. Thank you. I did not have a chance to review Mr. Waymeyer's motion. Actually, neither of your briefs. I'll take a look at those before I make a final ruling. Oh, I had one more question. No, never mind. I think you gave it to me. For probate, you did 8.2 hours at 300 hours at $300 per hour, right?
That's correct, Your Honor.
Okay.
If you look at the original fee award, you can. It says what time was spent at the probate judge, and the hourly rate at that time was $300.
Okay. All right. Thank you so much. You're free to leave.
All right. Thank you, Your Honor.
All right. Thank you. Before I start the second one, let me.
Good morning, Your Honor. This is Max Bone on behalf of the defendants in the move-ons. And I'm ready to begin whenever Your Honor is.
I am.
All right. And Your Honor, this case is the continuance of a case that has been before Your Honor for several years. And as part of my presentation, I was going to give some general factual background, although I know Your Honor has been involved in, I'll call it this case, although I know it's a separate one for some time. Would Your Honor like that factual background, or would you like me to just go ahead?
I am not recalling. Hold on for a second. Let me look real quick. Let me take a look at these notes real quick to see. You're saying this is one I've been involved.
So not this particular case. There was a lawsuit, a condemnation action. I'm sorry?
Kudzu.
Yes, correct. Kudzu was the defendant in the condemnation action, along with another entity, and this is a continuation of that. So
okay, I'm familiar. Okay, but you can give me the background, just refresh my recollection. You may proceed.
Your Honor. Mm-hmm. Thank you. And again, this is Max Bowen for the defendants, Mr. Nealon Hightower and Property Source One Associates LLC. We filed a motion to dismiss substantially all of the although not all of the claims. And Your Honor, can you hear me, or should I wait?
Yes,
you come back.
I better stop around. Sure. Everybody's concerned.
But we want to make sure you hear us, Your Honor. You're the one that's important today. We're just here to present positions.
I got you.
Thank you, Your Honor. And again, as I said, I know you've been involved in this case for several years, but I do think the background will be helpful just to bring Your Honor refresh your recollection, bring it back up to speed. So again, as I stated, the underlying judgment that created this cause of action for the city of Decatur and plaintiff was based on a condemnation action against Kudzu Capital LLC, another entity that I'm not remembering the name of, and it was about 4 acres of land. That proceeding was referred to as special master, and in May of 2018, the special master awarded Kudzu Capital, which I may also just call Kudzu, $2.18 million as the fair market value of the property at issue in that case. In that case, both Kudzu and the city appealed from that award. And despite the appeals, in August of 2018, this court entered an order making the special master's award a judgment of this court. So a judgment of $2.18 million. Kudzu Capital and the other entity received payment of those funds. The other entity was the lender for Kudzu. So they each Kudzu received after attorney's fees about a little more than $1.2 million. Fast forwarding several years after the appeal, and I believe Your Honor held my recollection is a 6-day trial on the matter, a jury awarded Kudzu a $1.4 million award, so $780,000 less than the special master had awarded. Kudzu appealed this court's judgment to the Court of Appeals, and in August of 2022, the city of Decatur sought to require Kudzu to post a supersedious bond as part of that proceeding. This court, on September 22nd, 2022, entered an order requiring that the supersedious bond be posted within 10 days, and it was not. So at that time, the city of Decatur could begin post-judgment discovery, but it promptly did. Fast forward about another year, May 21st of 2023, and the plaintiff filed this action. And the plaintiff's complaint, again, we're seeking to dismiss several claims or portions thereof, although not all of them, has 5 separate claims against Mr. Hightower and his company, Property Source One Associates. So the plaintiff is seeking, in this case, finding that Mr. Hightower was the alter ego of Kudzu Capital, has brought a fraudulent transfer claim against Mr. Hightower, has also brought a fraudulent transfer claim against Property Source One Associates, has further brought a breach of fiduciary duty claim against Mr. Hightower and a claim for successor liability as to Property Source One Associates, excuse me. We are not seeking to dismiss today the claim for the claim of successor liability. We are seeking to dismiss the remaining claims or portion thereof as part of this action, as I'll explain in just a minute. I think it's important to remember the standard for assessing a motion to dismiss, which is that the court takes true the well-pled allegations of the complaint. The complaint is certainly lengthy. By my recollection, it's about 230 individualized paragraphs, and there are more than 40 exhibits attached. And while it is thorough in some instances, it is not thorough in others. And it is the portions where it is not as thorough and the allegations are not as well pled that are important here today. I'm going to go ahead and begin with the alter ego claim. So an alter ego claim, the claim fails in this instance because the city has an adequate remedy at law. The city cites in their response brief the case of, it's a Georgia Supreme Court case, Bailey Lumber Company v. Thompson. That case is from 2005, and the quote I'm going to provide to your honor, we found at 279 Georgia 290. And in that case, again, relied upon by the plaintiff, the Georgia Supreme Court stated that a claim for piercing, and I quote, a claim for piercing the corporate veil is appropriately granted only in the absence of adequate remedies at law. And I think in this case, there are clearly adequate remedies at law. They're also being pursued as part of this matter. There are fraudulent transfer claims and a breach of fiduciary duty claim. And so, to the extent that there is an alter ego claim, which we contend is not, but also not a standalone cause of action, but it's rather a remedy that should be brought. There are other ways for the plaintiff to get what it is seeking. And so the alter ego claim is not appropriate in this context and should be dismissed. There are also, and so while the fraudulent transfer claims and breach of fiduciary duty claims are pending, that would not be the appropriate claim to bring, the alter ego claim. Moving on to the two fraudulent transfer claims, we contend that the majority of the allegedly fraudulent transfers occurred outside of the 4-year statute of limitations imposed by OCGA 18279. The plaintiff contends that they did not discover the claims with it. The second part of that statute says, or another portion of that statute says, that if a claim is, quote, if the claim is discovered, was or could have reasonably been discovered by the claimant then there is a 1-year statute of limitations rather than a 4-year statute of limitations. And the plaintiff contends that 1-year statute of limitations applies because they could not have reasonably discovered these fraudulent transfer claims. And so they filed their complaint timely. I think what's important here is the was or reasonably could have been discovered. The plaintiff contends and alleges in their complaint that they could not have possibly known anything about the allegedly fraudulent transfers until they were able to depose Mr. Hightower in May of 2023. As a debtor-creditor lawyer who does this sort of work, that doesn't exactly make sense to me. I see what they're saying, but at the same time, there are steps that can be taken, including you can do asset searches. We do that regularly in our line of work. We use a company that allows us to take a look and see what bank accounts an entity owns. And it sounds like they were very concerned about the bank accounts of Kudzu Capital pretty early on. And so in late September, early October of 2022, when they first began the process of doing post-judgment discovery, we contend that would have been a reasonable step to take, and they could have reasonably discovered the banks of Kudzu Capital where they were and subpoenaed those records. And they ultimately did subpoena the records from, I believe it was Truist and Bank of America. So there were steps that could have been taken, and they could have reasonably been discovered. These transfers, allegedly fraudulent transfers, could have reasonably been discovered prior to when they were. And so the 1-year statute of limitations has run. Those reasons.
All right, could you argue that again?
Certainly, Your Honor. So I'm a debtor-creditor attorney primarily. That's what I do. And as part of a standard, post-judgment discovery, and not just post-judgment discovery, but post-judgment steps to collect on our judgments that our clients receive, we will run either both a skip trace, so to see where the judgment debtor is, and then we will also do a bank account search. There's a company we use that does those for us. It costs us a couple $100s and takes about 3 days to get results. And so we contend that they could have discovered where Kudzu Capital had its bank accounts prior to when they claimed that they otherwise could not have, excuse me. And they didn't take that step. And so, the clock began ticking. So
you're saying step to use this company is a common step. Is that what you're saying?
Correct, Your Honor.
Okay.
Or at the very least, we do it. And I know that in my experience talking with creditor debtor attorneys, it's something that is done, done commonly because I think, as Your Honor has probably experienced, judgment debtors are not very likely to give you information to allow them to collect in the judgment, which is what happened in this case prior to our involvement in it. And therefore, it has never seemed reasonable to us to just kind of sit on your hands and say, okay, well, we're not going to do anything, not take any other steps until we get information from the judgment debtor. We take independent steps to confirm, where the individual is located, what assets they have, that sort of thing. And, setting aside, these are bank accounts, but in the context of real property and things like that, you would do things like property searches, and the skip trace would give you that. You also look at the property records of county. So there were steps that we believe reasonably should have been taken that would have reasonably led or that would have led to the bank accounts that being discovered that the plaintiff contends they could not have otherwise discovered until having done the deposition of Mr. Hightower, and those steps were not taken. So we contend that the allegedly fraudulent transfers at issue could have been discovered well before the plaintiff contends they were. Does that make sense, Your Honor? I hope I explained myself well enough.
I got it now.
Okay.
I just wondering more about that that company that you used and how common that was. Okay, thank you.
Certainly, Your Honor. And so for those reasons, we think the fraudulent transfer claim should be dismissed as they're barred by the statute of limitations. Again, some of them, or the majority of them, are past the 4-year statute of limitations no matter what. And of those that are beyond the 4-year, even that 1-year statute of limitations, there were steps that could have been taken that were not taken that would have allowed their discovery, and therefore they are barred under the 1-year statute of limitations as well.
Okay.
And if Your Honor has any more questions about that, I'm happy to answer them. I know it's a little bit, there's a couple of different things going on there, and there's some specific things that I said that we believe should have been done. Moving on to the claim for breach of fiduciary duty, and that's as to Mr. Hightower individually on behalf of Kudzu Capital. So the plaintiff contends that there were action that because Kudzu Capital became insolvent, which they contend occurred, and I quote, beginning as early as 2018, Kudzu was insolvent. That's paragraph 144 of the complaint. Mr. Hightower owed the city of Decatur fiduciary duty as of that time. But I think what's important to remember, as I said towards the beginning, is that Your Honor should only take allegations that are well pled as true. And a very conclusory allegation that beginning as early as 2018, Kudzu was insolvent, I don't think meets that bar. And there is a kind of tension in the complaint because at paragraph 231, the plaintiff alleges, and I again quote, Kudzu is insolvent, has no assets to satisfy the judgment due to the many voidable transfers that Hightower has caused Kudzu to make, because Hightower has used a large amount of Kudzu's funds to pay Hightower's personal living expenses. But there are, by my count, about a dozen allegedly fraudulent transfers that occurred in this case, and they're the only allegations related to liabilities of Kudzu Capital, which is what would have made it insolvent, are that as of May of 2022, the plaintiff had received a judgment of $780,000. And so, there's this tension here. In September of 2018, the complaint alleges that Kudzu received a little bit more than $1.2 million from its attorneys, but we have no allegations related to the liabilities of Kudzu, or no well-pled allegations as to the liability of Kudzu, and therefore when it may have been insolvent until much later, May of 2022. And so, again, I don't think that the allegation that just Kudzu was insolvent as of 2018 is well pled, so it should not be taken as true for one. And therefore, Mr. Hightower, as a manager and an owner of Kudzu, wouldn't have owed a fiduciary duty to Kudzu's creditors until May of 2022 at the earliest. And the vast majority of the transfers in this case, and the vast majority of the money transferred in this case by the allegedly fraudulent transfers, occurred back in 2018 and 2019. There are 4 transfers after May of 2022. And so we would request that Your Honor dismiss any claims as to breaches of fiduciary duty that to the extent that they are prior to May of 2022. And I believe that is it, Your Honor. There are some derivative claims here. There's a claim for attorney's fees, which would only exist to the extent that any of the other claims are successful. Again, we're not seeking to dismiss the successor liability claim today, but to the extent that the attorney's fees claim is based on the fraudulent transfers, the alter ego liability, or the breach of fiduciary duty, it should be appropriately considered in the context of we contend that some of these claims should be dismissed at least in part and in majority, if not in full. So to the extent that there is a claim for attorney's fees at the end of all of this, then it should be also treated appropriately as claims are dismissed or not. And I'm through with that, Your Honor. Again, as I said at the call of the calendar, I'd like to request about 5 minutes to respond to. I'm not sure if it's Mr. Sherman or Mr. Downs will be arguing today, but just a brief response to their arguments as well.
All right, who's arguing?
Your Honor, Jim Sherman. I'm going to be arguing on behalf of the city of Decatur.
Okay.
May it please the court, Your Honor. Again, I'm Jim Sherman representing the city of Decatur. With me is my colleague, Nicole James. She's going to help me with we have a few exhibits if we could share screen shortly. I'm also joined by Brian Downs, our co-counsel, and also observing today is Decatur City Manager Andrea Arnold. Your Honor, if I could fill in some of the details on the background of this case, it did start with a $2.1 million condemnation award that was paid and dispersed to Kudzu Capital in 2018. And that condemnation award was appealed. It led to a 6-day jury trial before Your Honor in 2022 over the value of the condemned property. And the way that those condemnation appeals work is if a jury determines that the value of the property is more than the special master award, then the city or the government entity has to pay the excess. If the jury comes back and says the property is less than the award, the condemned property owner has to repay Decatur, in this case, the amount of the difference. Here, the jury returned a verdict for $780,000. That was $780,000 less than the original condemnation award. So Your Honor entered a judgment against Kudzu, requiring Kudzu to pay to the city the sum of $780,000. Now, I'd like to make a point here, Your Honor. Mr. Bowen mentioned that there's not been sufficient facts pled about the insolvency of the property owner Kudzu Capital back in 2018. Well, we went into detail in the complaint and discussed the fact that when Kudzu filed that appeal in 2018 of the condemnation award, they faced the real risk that they would have to repay the city some of those condemnation proceeds. They faced the risk that the jury would award an amount less than the special master award, and they'd have to refund those monies to the city. And at that point in time, under Georgia law, Kudzu became a debtor, became a contingent debtor to the city.
A
contingent debtor to the city and owed a contingent liability, which in this case ultimately was $780,000. So when you're talking about insolvency in Georgia, and we tried many of these cases, it's not that complicated. There's two tests, either an inability to pay your debts as they become due, or the sum of your assets is less than the sum of your liabilities. And at that point in time, we've alleged that the city was a creditor of the debtor, Kudzu Capital LLC, and that Kudzu Capital LLC owed a debt. It was an unliquidated debt at that point in time, but nonetheless, it was a debt which we ultimately know was close to $800,000. So we have pled sufficient facts to show debts of the Kudzu Capital back in 2018, and we've sufficiently alleged that they were insolvent, which is a factual assertion which should be taken as true at this point in time on a motion to dismiss.
Now, his position is that you shouldn't, because your facts were insufficient. What were the facts?
Well, the facts were at that point in time, Kudzu Capital owed a debt to the city of at least $800,000, or was contingently liable for at least $800,000.
Okay.
It had received $1.2 million, but as soon as it got the money, Judge, they took it out in the form of fraudulent and voidable transfers. So their assets basically went to zero. So because of Mr. Hightower's actions, who was the sole manager and owner of Kudzu, siphoning all the money out in the form of fraudulent transfers, the company had no assets. So the company has no assets. We've pled that. That's clear throughout the complaint where we allege these fraudulent transfers.
So your position is because the money was removed, that meant that the contingent debt that was owed to the city was what the city would have been unable to be paid. Consequently, your position is they're insolvent.
That's exactly what happened, Your Honor. Mr. Hightower systematically drained the company of all of the cash it received in condemnation award. It got out of the $2.1 million, Kudzu got $1.2 million. Mr. Hightower promptly took $680,000 just for himself out of the company, and he moved another $250,000 into a separate entity that he owned and controlled named Property Source One Associates. So back in 2018, what occurs is Kudzu Capital is on the hook for a contingent liability, which ends up being $800,000 as pled in our complaint, and it has no assets because Mr. Hightower fraudulently conveyed all of the cash in the company's bank account to himself and to his other company, Property Source One. So based on those facts, Your Honor, we've pled and proven insolvency. You have a company that has an $800,000 debt, contingent debt, and no assets. And on top of these fraudulent transfers, Your Honor, Kudzu, Mr. Hightower, used the company like his personal piggy bank. Mr. Hightower didn't even have his own bank account. He paid all of his personal living expenses out of Kudzu's bank account. His food and liquor, his child support, his rent, his car, and all his credit card bills, he paid directly out of the company's bank account. And so after Mr. Hightower stripped Kudzu of all its cash, either in fraudulent transfers to himself or to his other company, he took what was left of Kudzu, which was just its real estate business, all its real estate activities, and he moved those into his other company, Property Source One. And then he shut down Kudzu. So he took all the cash in the form of fraudulent transfers or to pay his personal living expenses. He moved whatever business activity the company had and put it in his other entity, and he just shut it down. And that's just a classic case of a business owner through a series of fraudulent transfers trying to make his company judgment-proof so that Decatur couldn't collect the debt that ended up being close to $800,000.
Okay.
So that's why we filed this lawsuit, Your Honor, against Mr. Hightower and his new company. We asserted claims for the more than $900,000 in fraudulent transfers. We brought a piercing the corporate veil theory against Mr. Hightower. We brought a successor liability claim against Property Source One. Your Honor, the main argument that defendants made in their motion to dismiss when they briefed it was the statute of limitations argument. So I'll address that first.
Okay.
Nicole, can we go to Exhibit 1?
Mr. Sherman, I apologize real fast, Your Honor. We did receive these exhibits in advance. I don't have any objection to them being used. I believe all of them, with the exception of the 5th exhibit, were attached to the complaint. I think the only, I'll call it an objection for lack of a better term, that we would have as to the 5th exhibit, which is just a summary of a timeline. That's just kind of the contention is made therein that they're not being taken as true. They say what they say, but we're not waiving the right to contest that. To the extent Your Honor just takes them as truth, we would object only to that extent. So we don't have any issue with Mr. Sherman using them today.
All right. Thank you, Mr. Sherman. You may proceed.
Your Honor, I'm starting with Code Section 18279. This is the statute of limitations provision that's in the Voidable Transfer Act, and it provides the statute for a fraudulent transfer claim. It starts with a claim made under Code Section 18274A1. A1 is the prong of the fraudulent transfer statute that's for actual fraud, where a debtor acts with the intent to defraud a creditor by making a transfer from an insolvent company to hinder, delay, or defraud a creditor. And we are claiming that Mr. Hightower caused Kudzu to make these transfers to himself and to his other company that's more than $900,000 with the actual intent to defraud the city. That's an A1 claim. And an A1 claim is timely if it is brought within 4 years after the transfer was made. This is under subsection 1. Or if within 1 year after the transfer or obligation was or could have been discovered by the claimant. So there are two periods. It's the later of 4 years from the date the transfer was made or 1 year from the discovery of the transfer, whichever is longer. The city was traveling and has been traveling under this 1 year add-on period, which applies when the transfer was discovered. The defendants in their motion completely disregarded and ignored that 1 year discovery period, and they simply argued that 4 years had elapsed from the time of the transfer. So they disregarded the 1 year add-on provision. But the focus then on the 1 year add-on provision, Your Honor, is when did the city discover the claims or could have discovered the claims? And Your Honor, we've alleged in detail in the complaint the efforts the city made to obtain the most basic financial records from Kudzu, the bank statements, their financial statements, their tax returns. Mr. Bowen admitted that as soon as that judgment was entered, we promptly, to use his word, we promptly began post-judgment discovery to get these financial records. Kudzu never answered any of our document requests, or they answered the first one and they objected to everything and refused to produce documents. They wouldn't answer the other document requests. I've detailed all of this in the complaint, Your Honor. I asked to meet with Kudzu's counsel to get these records. He refused to meet with me. I wrote multiple times asking for returns and bankruptcy and bank statements. I got no response. Your Honor, the city was super diligent in investigating Kudzu's finances. I hear today for the first time that they critique us for not getting a asset search, what they say would have revealed these bank accounts. In my experience, these asset searches miss bank accounts more often than not. And even if they had listed the bank accounts, we still have to go to the banks to get the bank statements and the checks. The asset reports don't show the transactions that have come in and out of the bank accounts. They don't show the checks. They don't show the activity in these accounts. So that wouldn't have disclosed what these fraudulent transfers were when they occurred. And the other issue that the defendants gloss over that's important for this court to understand is it's not enough just to know when the transfers were made. The cases that deal with this 1 year add-on statute of limitations provision all say that you have to have facts that show that the transfers were, quote, fishy, that there was something about them that was fraudulent. And that can only happen once you understand the facts and circumstances surrounding a transfer. Why it was made, who it was made to, when, was it in satisfaction of an antecedent debt? Was there value given for the transfer? We don't have any of that information just on an asset search report. The only way to get that information is to depose the person who made the transfer, which in this case was Neil Hightower. And we did that in May of 2023. So just to back up for a second, Judge, what happened after the defendants refused to produce any of these financial documents to us? We had to get the court to intervene, and we asked Your Honor to hold a conference over Zoom so we could talk about the defendant's failure to give us the financial records. And if we could go to Exhibit 2, Your Honor entered an order in April 2023 that directed the defendants to provide us with certain information. If we could scroll down. Your Honor directed the condemnee, Kudzu Capital, to tell us what they did with the money they got, the $1.2 million, where it went into the bank and what happened to it. And then Your Honor directed Kudzu Capital to give us the name of the bank account and the bank account number where they maintained all their cash accounts. And so that was in April of 2023. Once we got that information, we were able to subpoena the banks in May of 2023. We finally got the bank statements. We finally got the canceled checks, and we took Mr. Hightower's deposition in May of 2023. if we could go to the timeline, Nicole, which is fine. Your Honor, this is kind of a timeline that we sketched out that shows when our efforts began to obtain the financial and tax records and bank records of Kudzu Capital. If you'll see on the bottom, beginning in August of 2022 and continuing through April of 2023, we worked super diligently to get the bank statements, to get the tax returns, which we found out Kudzu's never filed any tax returns, and the financial statements, which we found out Kudzu has no financial statements. So we investigated throughout those 8 or 9 months what happened to the money that they got from the city, where the transfers were made. And again, we don't have knowledge of a fraudulent transfer until we learn that there's something suspect or fishy about the transfer. And that occurred when we took Mr. Hightower's deposition in May of 2023. So in May of 2023, that is when the 1-year statute of limitations commences. In May of 2023, and it runs till May of 2024. And we filed our complaint.
When the date of the first transfer?
The date of the first transfers occurred in 2018, as soon as they got the cash from the city. That's why they became insolvent.
The real property. You said there was some real property that was transferred.
Well, they had, the company is a real estate investment company. That's what Kudzu Capital did. And they did have, one of the fraudulent transfers we contend is they had an asset, they still own a piece of real estate that they put a big debt on to their lawyers. And so we contend that security deed they gave to their lawyers was a fraudulent transfer. Okay. But what happened, Your Honor, is this company would buy and sell real estate. That was their business. And as soon as the money was dispersed to them in 2018, they moved all their real estate buying and selling business to another company. So they basically took all their operations and discontinued them and started up a new company so that we wouldn't have anything to collect from it when we got our judgment.
Okay.
So, Your Honor, one thing I want to mention, I was concluding with this exhibit. We have a 1-year window that begins in May of 2023 to file our fraudulent transfer claims. We filed them in November of 2023. We're well within that 1-year period. And I will point out, Your Honor, that the question of whether a plaintiff and when a plaintiff could have reasonably discovered a fraudulent transfer is a question of fact for the fact finder to resolve at trial. It's not something that can be disposed of on a motion to dismiss. And the case on that is Merrill, M-E-R-R-I-L-L, Merrill Ranch Properties. And that's at 336 Georgia Appeals. And let me get the full site for you. I know that particular pinpoint site is at page 733. I'm not sure the page number where that case starts. It's at 722, 336 Georgia Appeals 722. So even accepting everything Mr. Bowman says is true, that we could have discovered this bank account back in August of 2022 or September of 2022, we still wouldn't have known the transfers were fraudulent, meaning that they were made with the intent to defraud us until sometime in 2023, in May of 2023. And even then, the question of whether the Decatur promptly pursued this discovery and when they could have discovered the transfer, that's a question of fact to be determined by the fact finder at trial. So, Your Honor, we say that those fraudulent transfer claims were brought timely within 1 year of when Decatur discovered or could have discovered those transfers. Your Honor, unless you have any questions about that, I'll turn to the alter ego claim.
You can.
The alter ego claim is the argument the defendants made today is not the argument the defendants made in their brief. In their brief, the defendants argue there is no such thing as a standalone alter ego claim in Georgia. We provided the case that the Georgia Supreme Court decided that they cited to Your Honor a few minutes ago, which says, yes, a piercing the corporate veil theory is a standalone claim that can be brought against in this case, an LLC's member. They don't seem to quibble with any of our facts that Mr. Hightower used the company's bank account as his personal piggy bank, that he disregarded the separateness of himself with the entity Kudzu Capital LLC, that he bled the company dry by misappropriating assets, leaving it hopelessly insolvent and unable to pay the judgment. What they say is, well, you got an adequate remedy of law, so you ought not to be able to bring that claim. Your Honor, what happens, I've faced this argument a lot in creditor cases recovering these debts, and people always throw out, well, you have an adequate remedy of law, but they skip over what adequate means. An adequate remedy means that there's money, it's not just that I have a legal claim for money damages, it's that I can collect it. That's the adequate part of it. And here, I don't have an adequate remedy of law because Kudzu Capital doesn't have anything anymore. They have no assets. Mr. Hightower siphoned all the cash out of the company and left it broke. So when they say I have a remedy at law, it's just not an adequate remedy at law. And that's why we're entitled to pursue an alter ego claim. All right, I'll touch real quickly on the brief of fiduciary duty claim. There is a long, long line of cases in Georgia that says when a company becomes insolvent, and we've pled facts to prove this company became insolvent as early as 2018 when Mr. Hightower took all the money out. But when a company becomes hopelessly insolvent, the managers owe a fiduciary duty to the creditors to conserve and manage the assets of the company. And they can't take any action to misappropriate or waste the company's assets to the detriment of creditors. And Georgia is very unique with this breach of fiduciary duty statute or case law. And the breach of fiduciary duty is owed directly by the manager of the company, here Mr. Hightower, to the creditor of the company, which is DeKalb. And Your Honor, the statute of limitations on this claim is 6 years. And we provided the case law about that in our brief. And here we have a violation of the clear violation of these fiduciary duties because Mr. Hightower misappropriated all the assets of Kudzu Capital by making these fraudulent transfers to himself and to his other company, Property Source One. So it's a classic breach of fiduciary duty claim. I had tried this claim many times. We tried it in front of Judge Jacobs in state court 2 years ago and recovered a 6-figure verdict on that. So that's the breach of fiduciary duty claim. So, Your Honor, that leaves the attorney's fees claim. Essentially, Your Honor, these are intentional torts that we pled. Fraudulent transfer claims are intentional torts. Breach of fiduciary duty claims are intentional torts. Those carry with them the ability to recover attorney's fees for bad faith. That's what our position is on those. And so in concluding, Your Honor, we're asking the court to deny the motion to dismiss in total and let the case proceed. Are there any questions I can answer for the court?
No, not at this time. Thank you. If you would stop the share screen there. Okay, Mr. Bowen, you said you needed a few minutes thereafter.
Yes, Your Honor, just I would say 5 minutes or less, so I can make it quick and we can wrap this up. Okay. So just to respond to a couple of more characterization things that Mr. Sherman said, he's correct that in our initial brief we didn't make some of the arguments we're making here today. We did not file a reply brief, so some of these arguments are being made directly in response to arguments that were brought up in the response brief. So while they were not in writing previously, they are directly in response to arguments that were made by the plaintiff. Mr. Sherman also said that we don't, I think the term used is quibble, but the characterizations made in the complaint about things like siphoning of assets and, personal piggy bank and things like that. This is a motion to dismiss to the extent that the allegations are well pled. They should be taken as true, excuse me. I think we dispute the characterizations in the sense of, if the statement is that it was his personal piggy bank, I mean, the allegations are the allegations, the characterization of the allegation is what it is. And it's not productive, I think, to go, paragraph by paragraph and say, well, in this place, it's, we're saying he didn't treat it like a piggy bank, or in this case, he didn't siphon it off. I mean, the complaints were replete with those. So they are what they are. I think Your Honor can take them for how Your Honor would like to take them. I think, and I'll start with the insolvency piece again. The plaintiff's contention is that there was a contingent liability as of the date they appealed from the special master's order. I would say that even taking that as true, the complaint admits that Kudzu Capital received a little bit more than $1.2 million, and then the contingent liability would have only been $780,000. And so that was decided much later. I'm going to set aside for just a minute, whether or not that when the fiduciary duty would have been created for Mr. Hightower as to Kudzu's creditors. But then you still have a delta there of more than $400,000. And so you would have to look at the complaint and the specific transfers made therein in order to determine, hey, when did we dip below that $780,000 amount on the various transfers? And I think that's important because if the contention is that you needed to keep the entity capitalized to the extent that it's got enough to cover a claim, that was the number. So if you're going to have assets above $780,000, I'm not sure why there would be any violation of a fiduciary duty to a creditor if you have that much money in an entity. So I think that's one thing to look at. The other thing too is I think that it's
the position was there was no money. So
I'm sorry, can you say that one more time, Your Honor?
I'm a little confused on that. You said that you're saying that at some point Kudzu had the money in the account, but
that's correct, Your Honor.
He took it out immediately.
So if you actually look at the allegations in the complaint, Mr. Sherman characterized it in the complaint, largely characterizes it as a systematic, I'm not sure what the exact word is, systematically taking the money out. And it's not like, on one day it received $1.2 million, on the next day $1.2 million went out. There were several transfers made over a period of months of varying amounts. And I'm not sure if Your Honor has the complaint pulled up in front of her, but if you look at paragraph 235, and then there's subparagraphs 1 through 8, and that's on page 27 of the complaint, and then paragraph 242, and there are subparagraphs 1 through 7. That's on page 29 of the complaint. And so those are the dates. And we're not contending that, they got the bank statements wrong, they got the dates wrong. And I think the dates are important in the amounts. But if you look at those dates and those amounts, it wasn't like it happened over one day. As by way of quick example, paragraph 235, subparagraph 1, they contend that Mr. Hightower made allegedly the fraudulent transfer of a little less than $25,000 on October 29th, 2018. And then the next allegedly fraudulent transfer, paragraph 235, subparagraph 2, was made on December 21st, 2018, of a little more than $300,000. And so again, if the contention is that we have a debt of $780,000 in a judgment against Kudzu Capital as of some point in October 2018, I think it would be important to consider, when did the assets of the company end up below that $780,000 mark? And again, that's setting aside whether or not we're agreeing for purposes of argument there was a debt. And I'll get to that in just a second. And if Your Honor's taking notes, I'm happy to stop and then continue.
No, go ahead.
So I think that would be important to look at in terms of when there was a breach of fiduciary duty claim, or when there would have been a fiduciary duty, and therefore when there was a breach of that duty, as to Mr. Hightower and also Property Source One.
But how is that a motion to dismiss? If their position is that they're claiming that there was a duty they're claiming that, I mean, even from the beginning, their position is that there was a potential contingency debt from the beginning, and therefore that duty would have almost, I believe, with the case law on it, would have been almost immediately if, in fact, there was a contingency debt, then he would have had that duty. The question would have been when he breached it, but I don't know if that's an issue for the motion to dismiss. Right?
I think Your Honor has it right that there are those two separate parts. But in terms of whether or not there was a breach on the motion to dismiss stage, the complaint says what it says. Again, if we take the allegations as true and the dates as true therein, my contention is that there was not a breach as pled in the complaint until at least when the assets of Kudzu Capital were less than $780,000. And therefore, if the assets were ever above $780,000, then there was just not a breach, and therefore the claim should be dismissed as do those other transfers.
Okay. All right.
Moving along to whether or not when there was a contingent liability.
When is that? I mean, how am I supposed to make that decision?
So I think it's actually relatively easy. Again, if you look at the paragraphs of the complaint, so that we're going to take us through the allegation that Kudzu Capital, as of sometime in September of 2018, had received, it was late September 2018, had received a little more than $1.2 million from the law firm that received the funds from the clerk.
Okay.
So at that point, if you take $1.2 million on one side and $780,000 on the other, you can just look at the dates of transfers and say, okay, on October 29th, 2018, did that transfer create a breach constituting a breach of fiduciary duty? Well, $25,000 off of $1.2 million does not take you below $780,000.
Okay.
So then the next transfer, the $300,000 transfer in December of 2018, does that take you below $780,000? So if the contention is that you have to preserve the assets for the creditors, well, if there are assets for the creditors, if that would have existed at the time that they're contending a breach occurred, right, my contention is there would have been no breach. It wouldn't have been until you dipped below the $780,000 mark in the entity until you wouldn't have a breach until that point.
Okay, but there was at some point that breach did occur.
Right. Assuming for the purposes of this argument, I'm going to get to that in just a second.
So yeah, because we have to accept it as true.
Right. Correct. But I think the other contention, and this is what I said initially, and Mr. Sherman had responded to, was that the fiduciary duty didn't arise until the later date, until May of 2022. And so he's contending that there was a contingent liability. I'm not sure, we both cited to some cases today. I'm not sure what.
That's what you're saying.
Yeah, I'm not sure about what would create the contingent liability, what statute or case law would create the contingent liability. I mean, I think that when you have a judgment, right, if you have a claim, and I get the concept of for the Uniform Avoidable Transfers Act, you have a claim, therefore you are a creditor. We're not conceding today that that automatically gives you a contingent liability for purposes of a breach of fiduciary duty claim.
I think the way that he's arguing is that the statute in of itself indicates that there are two things that's going to happen. Either if you contest this 1.2 million, then I'm going to end up owing you, or you're going to end up owing me, potentially. And so I think the concept is that Hightower would have been, or the company would have been on notice that they potentially could owe the county, and consequently should be taking care such that if that becomes due, it can be handled and paid for, because that's what he's contending with his contingency debt situation.
Certainly, Your Honor, and I think that our position on that is there's not any case cited today, statute cited today, that in the context of a breach of fiduciary duty claim that would qualify for purposes of maintaining a fiduciary duty.
Okay, got it.
Moving along to diligence, Mr. Sherman even said that he just simply doesn't see the worth in an asset search. I mean, we can just disagree on whether or not we think that's a viable way to approach collecting on a judgment. I think that going back to what I said initially, we do think that is a way to get that process started more quickly. You're not just relying upon a judgment debtor to give you information. You are doing your own things, and certainly, you could run an asset search, and if nothing pops up, then nothing pops up. But if things do pop up, it would be a reasonable step to subpoena bank records from the bank accounts that you would search. And it seems as though what Mr. Sherman said is that step was not taken. So we would contend that would be a step that would constitute reasonable diligence and would provide them the information faster than they could have had it. Faster than they did have it.
His argument on that is, okay, I would have found out that he had 3 accounts. I'm just making up something at Truist Bank. Now what? That information doesn't lead to the concept of whether there was a transfer or whether it was even considered fraudulent or speculative or fishy or whatever. So let's assume I had that information 2 months earlier. He still would have needed to conduct this post-discovery or kind of look up on some other evidence that would have made it clear that this is fraudulent. Otherwise, he would have been filing lawsuits on fishing expedition, for which I would have been like, we don't do fishing expeditions here.
Certainly, Your Honor. And Your Honor's point is well taken, Mr. Sherman's point is well taken. But I think that what's very telling about this complaint is there are a lot of conclusory allegations about the transfers being fraudulent, and the term Mr. Sherman used was we wouldn't have known they were fishy until a deposition. There's no deposition transcript cited to. So our contention would be that the way the complaint is pled, it's not well pled for purposes of a motion to dismiss. So you shouldn't just be taking that as truth. Well pled would, if they're going to contend, okay, we didn't know until May 2023 until a deposition. Well, what was in the deposition? That would constitute a well pled complaint for purposes of the motion, and therefore Your Honor should take it as true. And again, I'm not this is as far as complaints go, it's thorough in a number of ways. There are extensive exhibits. It's an extensive complaint. It lays out things in great detail. That doesn't mean that every single thing should be taken as truth. And we would just contend that in order for an allegation to be well pled, if you're going to say, well, now we do as of the date, as of the deposition, you should be citing to the deposition and showing the court that, hey, this is what we're contending constitutes justifying a fraudulent transfer claim. So on one hand, they're saying, well, we didn't know until we took the deposition. On the other hand, they're not providing any evidence of what was in the deposition in the complaint such that it would be well pled and therefore taken as true for purposes of this motion.
Okay.
And finally, the alter ego claim, Your Honor, just quickly, it's not just that there are, inadequate remedy at law against Kudzu Capital. If they're contending that, Kudzu has no money and therefore we need an adequate remedy at law to go against Mr. Hightower, well, there are two other currently pending causes of action. There is a breach of fiduciary duty claim for the same damage, which would essentially be for the same judgment that that exists for Kudzu in the same amount. And there is also the fraudulent transfer claims. And so those would be those adequate remedies. If you want to contend that Mr. Hightower is the alter ego of Kudzu Capital, well, you're already taking steps to make him liable for that judgment through the nature of the fraudulent transfer claims and the breach of fiduciary duty claims. So to the extent that there is the alter ego claim pending while those other two claims are pending, we would contend that the adequate remedies to pursue those other claims. To the extent that the breach of fiduciary duty claims and fraudulent transfer claims are not pending, then the alter ego claim would be much more appropriate.
But by the same token, if you did that, aren't you wasting potential money, and isn't that not efficient? I'm just saying, like, if you would end up going, oh, I didn't get what I wanted from that one. Let me do the alter ego and we start this whole discovery process. Wouldn't you be starting everything over? Like,
you certainly could be, although in the context of this particular factual situation, we're faced with a motion to dismiss where all of these claims are being brought. And so what we're asking Your Honor to do essentially is to say, you can either bring the alter ego claim or you can bring the breach of fiduciary duty or the fraudulent transfer claims. So now that we're before Your Honor, they pick both. Now we're asking Your Honor to say, pick one, pick that lane. What's the remedy that you would like to seek?
All right. Thanks so much.
Thank you, Your Honor. And I have nothing further.
All right. Thank you very much. I'll take it under advisement. Ms. Harris, if you give me a call.
May we be excused, Your Honor?
Yes, you may be excused.
Thank you.
Thank you, Your Honor.
All right. So we got a few motions. Let's see. We're going to write that down. So we can figure out. All right. So do you all want to start with the motion for summary judgment first, and then then we'll look at those are more of the side motions as we go?
We can, Your Honor. Any order that makes it clear. Well, if that's the most important motion, so yeah. I have the others are kind of ancillary, even though some of them need to be addressed.
Okay, let's start with the motion for summary judgment.
Okay.
All right.
You ready, Your Honor?
I'm ready. Mm-hmm.
Okay, thank you.
So just so I turn my off. Usually if I'm drinking coffee or something, I'll just turn the screen off. I'm here, okay?
Okay.
All right.
Your Honor, my name is William Jones, and I'm representing Noble Insight in this matter. And the underlying case is a breach of contract claim against a corporate defendant and a personal individual. So there are two defendants in this matter. And the motion for summary judgment is brought on the basis, because it would seem early in this litigation for someone to be claiming that they are entitled to some type of summary relief. But the basis for the motion for summary judgment is the default status of the corporate defendant. And so that would be, I guess, addressed more clearly in the other motions pending. But the motion for summary judgment, when we make the claim that based on the entire file, the pleadings, the deposition answers, that there's no genuine issue, it's that the default status has deemed the allegations in the complaint admitted. That's under the statute. And so because of that, plaintiff is seeking summary judgment on liability. And so as the backdrop, the complaint in this matter was filed on October 10th, 2023. And the defendant, the individual defendant, is also the registered agent for the corporation. And they were served on November 6th. And so that then starts the clock for when an answer is due. And well, the clock starts ticking for when an answer is due upon service. Okay. So when an answer was due, an answer was filed on behalf of the individual. But on behalf of the corporation, a motion was filed for an extension of time to file the answer. And that was addressed. That's the substance on the motion to strike, because that provision, what we allege, is that that's not allowed under Georgia law. What could have happened but didn't was that an answer could have been filed on behalf of the corporation and it could have been amended. The law allows for that, but that is not what happened. No answer was filed on behalf of the corporation until February the 5th. Okay, and so again, the law allows a late answer to be filed. If you're in default, you would then have to file a motion to open the default. And then the statute lays out 91155B, a prejudgment default may be opened on one of three grounds if four conditions are met. The three grounds are providential cause, excusable neglect, and a proper case. The four conditions are a showing made under oath, offer to plead in stanter, announcement ready to proceed with trial, and setting up a meritorious defense. Okay. The question of whether to open a default on one of the three grounds noted above rests within the discretion of the trial court. That's the standard rule. While generally the open of default rests within the sound discretion of the trial court, compliance with the four conditions as a condition precedent. In its absence, the trial court has no discretion to open the default. So you have to go back to see whether these conditions precedent were met. We are saying that it was not met, and therefore the default has not been opened. And the only document that even addresses opening the default, again, we're looking back at another document, was in response to my motion to strike. The corporate defendant, the last sentence says, and in the alternative to open the default judgment. Okay, so in looking at that document, I then tried to find where these conditions were laid out to even allow the court to have discretion to open the default. It's nothing there. And actually, that document alleges that it was amending a prior pleading, which I think counsel then understood that he was late, because there's no other pleading for the corporation that had been filed up until that point. Okay, and this document, when the provisions on opening default, it does not state or provide what the court needs to be able to grant the opening of the default. All it states is that what the it cites 91155B and kind of moves on, which is totally inadequate as a matter of law for the court to be able to exercise its discretion. And so on that, I then said, well, you're in default. I need to nail that down. And so then the summary judgment then contemplates, you look at the entire record, and it comes down to whether the answer was late, well, whether an answer was filed, whether the answer was late, and if it was late, if you're in default, whether the default was properly opened. That, Your Honor, is in summation. I mean, I can't distill it down. You can look at the dates and things in the conversations back and forth, but that's the essence of the motion for summary judgment, because once you're in default, then all the allegations in the complaint are deemed to be true. That then supports the liability portion, not the damages portion, the liability portion on the motion for summary judgment.
All right, could you give me 1 second? My file went back down and I can't see the docket. So give me 1 second. Okay, so when I went through the first time, I was trying to see on the whether there was a motion for default. Was there a motion for default?
No, there was no motion for default, Your Honor. But under the statute, the default is automatic. So if you were to make the motion for default, it would be the same result. But the issue I had was that I wanted the entire record to be seen, because the default normally only goes to whether or not an answer has been filed. So in this instance, an answer had been filed late. So the issue really is whether the default, which is automatic, has it been opened properly. And you can only do that if you're looking at the entire record.
Okay, you're saying you didn't file for default because what now?
I did not file for default. I did not file for a default judgment because an answer had been filed. They filed an answer on February the 5th. It was filed late. Your normal default is when an answer hasn't been filed. You're in default automatically after 30 days. The only question after that is whether you've opened it. And after reading that they had not opened the default properly, then summary judgment on that issue is proper. Because I wanted the court to be able to look at the entire record, which there's requests made for motions for an extension of time. That normally isn't relevant in a default, but it would be in a motion for summary judgment.
Okay, so I'm trying to look. Okay, so service, let's see, I have a couple of service things here, so let me take a look. So we have your petition, you filed that on 10/23. When was MVP and when served?
They were served on November
7th?
November 6th, Your Honor.
November 6th.
So the answer would have been due December. Okay, and so the answer came on the 6th, which would have been a day late.
For one defendant.
No, that was timely.
For one defendant.
I thought it was no. How many days? How many days does November have? 30. November has 30.
No,
November
has 31. Excuse me.
30. Yeah. So I think it was supposed to be the 5th. If you're using 31 days.
The 5th was a Sunday.
Oh, the 5th was a Sunday. Okay.
Yes, Your Honor.
Okay. So then go back to you, Mr. Jones, one more time. You're saying this answer. Your position is the answer was late because
you're looking at the answer that was filed by the individual.
Okay, got it. Okay, so I'm looking at.
Look at the answer filed by the corporation.
Wynn. Okay, so that's Miss Wynn. All right, so let me go to there's a motion for extension of time. Motion for extension of time to file an answer on behalf of the corporation. December 6th. Okay, so normally I would give time. Okay, got it. All right, anything else, Mr. Jones?
That's the summation and the basis for the motion for summary judgment.
So your position is that liability attaches and basically the issue becomes one of damages.
That is correct, Your Honor.
All right, thank you, Mr. Simpson.
Yes, Your Honor. So as you've ascertained, and as Mr. Jones has said, the summary judgment motion really depends upon whether a valid answer exists on the record or not. The facts are really kind of unfortunate. Ms. Wynn was attempting to find counsel to represent herself. She was struggling to find counsel to represent herself. So on represent her company, excuse me. So on December 6th, she filed a motion to extend her time to answer so that she could find counsel. She found counsel in December. However, that individual suffered from a stroke, so she had to restart her search efforts. She came to us in January and retained us, in which case we instantly filed a response to the motion to strike her motion for extension, and in the alternative to amend her motion to extend so that it was written under our signature or to open a default. So we have basically 3 avenues where this matter can proceed on the merits. Number 1, the court can simply grant Ms. Wynn's motion for an extension of time to file her answer. Number 2, the court can substitute.
Her answer has already been filed. It's the corporation's answer.
Correct. File the corporation's answer. That's correct. Yes.
Now, why would the court do that if, according to the case law and the statute that Mr. Jones has presented, you only have 15 days to open the default? And then under those 15 days, there's certain parameters. And I know you've made a request to open the default, but it's certainly after the 15 days. Is there any case law or any consideration that the court has when those 15 days has passed?
Correct, Your Honor. So you have 15 days to open the default as a matter of right. So that wouldn't have even required judicial intervention whatsoever. If we had been retained and had been able to file a motion to open the default within 15 days, the default would automatically be opened and we would be proceeding and there would be no issue even before the court. To open a trial court can open a default at any time that it wants to, and it can do that upon either excusable neglect, providential cause, or a proper case. A proper case is the broadest authority that a trial court possibly has. It can invoke that when, for any reason it wants to. Quite frankly, it can invoke it simply if it feels that in the interest of justice, the case should be heard on the merits, which is what we would argue here. But we would also argue that there's excusable neglect in opening the default, that the trial court has the ability to open the default for excusable neglect. And that excusable neglect is quite simply the fact that Ms. Wynn was unable to retain counsel, and the counsel that she did retain suffered a serious health episode and was unable to proceed with her representation.
Is that counsel?
Excuse me?
Is that counsel now available? Is he well?
No, Your Honor. And so myself and my co-counsel, Genevieve Hill, have accepted representation of Miss Nguyen following his health episode.
So he's not now practicing?
Correct. He is not now practicing. It's my understanding.
Okay.
He's not been able to return to practice.
Okay.
Mr. Jones mentioned that there are a couple of parameters that a party needs to do to open default, or to give the trial court the discretion to open a default. And Mr. Jones said that we had not satisfied those. I'd respectfully say that we have satisfied those. The requirements are that you file an answer. We have filed an answer. That you plead instanter. We pled instanter by virtue of filing an answer. That is the case law says that is basically the same as pleading instanter, as filing an answer, and payment of court costs. And we have paid the court costs. So I would reiterate again, there's a strong policy preference for cases to be heard on the merits. This case is going to have to go forward on the merits, regardless of whether a default judgment is entered or not entered, because Ms. Nguyen is still going to be defending herself individually on the merits. So there's no additional work, prejudice, anything like that happens from opening the default here. And it does give the court the opportunity to actually hear the case on the merits, rather than dismissing as to one individual for procedural deficiency. And again, Georgia Court of Appeals has routinely upheld trial courts' decisions to open defaults for proper case. The case law is very clear. That is the broadest authority a trial court could have. And so we would respectfully submit that in the interest of justice, that the court accept P3's answer, and in accepting P3's answer, deny and open the default and deny Noble Insight's motion for summary judgment, because if a valid answer has been filed, then there is no basis for a motion for summary judgment.
Okay. I'm going to deny your motion for summary judgment, Mr. Jones. I'm going to deny it because one of the things that I am very particular on, and that's being consistent. Usually when people come before the court and they have answered for their corporation, I always give them 30 days. That's just a lot of times when they're smaller corporations, I always give them 30 days to find counsel. I was actually surprised to find that this motion went unresolved. Like for normally, I would have said something like, there's a provision that I have. It's a common boilerplate order that I have. I think it's Eccles versus, what's that? Do you have that boilerplate language? What was the name of that case law that we always cite? Do you recall?
Atlanta Technology.
I'm sorry?
Atlanta Technology.
Eccles versus, I'm sorry, what is it? No, this is
Eccles versus Atlanta Technology.
Eccles versus, yeah. I have a boilerplate paragraph. I always give, anytime an individual comes and they try to answer on behalf of a corporation, I tell them that's not proper, you can't do it. I always give them time to find counsel. That's just generally what I do. Now, that doesn't mean that that's something I would do in every single case. For example, if this case was one of those where a person was not responding and you had, there has to be some extra facts or something that would make it look a little bit different, and I might do something different. But usually if an individual comes on smaller companies and asks and try to answer, I always give the additional time. So your motion is denied. That would ultimately also deny your motion to strike as well. I don't grant her motion because she cannot file on behalf of the corporation. I just send an order out giving her or giving whoever it is the additional time, usually 30 to 45 days. Normally, I give that time, but because I can't answer her motion because she can't file that motion. But that's generally what I do. So to stay consistent with what the court has previously done, I'm going to deny your motion. If you have filed an order to that effect for me, Mr. Simpson.
Your Honor, two things. I have a motion to compel, and counsel would note that I requested a finding of fact and conclusion of the law on that summary judgment motion, so that shouldn't be a problem. The only other outstanding issue is the motion to compel, and at this point, I think they have, basically complied, but my client expended funds in me having to file the motion because they filed. You may need to just look at the motion because I included their responses, but it ended up being basically not answering any of the questions. Then I said, you need to amend, gave them 2 weeks to do that. They didn't do that. And then I filed the motion to compel. And then after that, I then got some adequate responses. So what my client is seeking with respect to the motion to compel is the fees for having to file it and to get this far on it.
How much is that?
That is, I've got 3.5 hours at $4.50 an hour. That's $15.75, Your Honor.
All right. What's your position, Mr. Simpson?
Yes, Your Honor. So our position is we've attempted to comply and just work through good faith discovery disputes throughout this process. So when our firm made an appearance in the matter, the discovery responses were due the next day. Given counsel's prior opposition to the motion to extend P3's time to answer, we did not believe, we thought that it was in the best interest to just go ahead and make sure that we filed the objections. We then subsequently went through to provide substantive responses to those objections and followed up with substantive responses and over 200 pages of document production, which we felt fully complied with the discovery request. Mr. Jones then reached out to us last week with a second good faith discovery deficiency letter. We held a phone call on that to discuss what concerns he had, because we felt that our responses were fully compliant to begin with. He raised a couple of additional concerns that we said, that's not a problem. If that's what you want, then we can amend the responses one more time to address what concerns you had. And so we did that. So, Your Honor, we would argue that the motion to compel was premature to begin with, that there had been no actual good faith dialogue back and forth about how to fully respond to the discovery request. We'd also note, I think in our opposition brief, we noted there have been courts that have said that it's in the, oh, sorry.
What do you mean by that? He sent you, what do you mean by good faith? Isn't his letter the good, isn't the letter the good faith?
I think that his letter certainly serves as a starting point to an attempt to resolve issues. But I think that sending a letter and then immediately filing a motion to compel is premature without picking up the phone, calling counsel, especially since he knew from the record that we had filed a notice of appearance in that case days before. And I would, again, submit, Your Honor, that, we have gone to great lengths to provide Mr. Jones. I mean, there's some of the requests that we think are objectionable. I don't think that, I think that a lot of our objections actually do stand. Mr. Jones, counsel's discovery requests are overly broad, so we believe that our objections would stand on the merits. For example, they asked for any and all emails between the parties without restrictions to date ranges, subject matter, anything of that nature. They asked for any and all invoices between the parties without regard to date range, subject matter, or anything like that, when the parties have a lengthy, decades-old history. So we actually do believe that the requests in and of themselves were objectionable, and that our objections could stand on their own. But we're not here to just try to say, stonewall you and say, here are the objections. We went back, provided the information that we thought that he was asking for, and provided all of that.
Let me go back. So here's what I'm looking at. That the answer so he files it in October. I think he serves it on November 6th. The answer would have been due on December 6th. You serve your response. You serve your discovery with your complaint.
No, I didn't, Your Honor. I sent it separately.
Okay. What date did you send your discovery back?
I'm looking at the, I have the motion in front of me. Exhibit A is my notice to counsel on the attempt to resolve discovery disputes. And it says that on January 26th, they submitted the responses.
I know, but when did you send it to them? That's why I thought you sent it with your. No, I sent it after that. I'm gonna just hold 1 second, Your Honor. Let me, because I actually got to the dispute before I got to the, well, it will be in my.
Just to clarify,
it will be in a certificate of service.
Ms. Wynn an extension until January 26th. Yeah. So there was an email communication between Mr. Jones and Ms. Wynn where she said, I'm trying to retain additional counsel. My counsel suffered a stroke. May I have an extension to respond to discovery? And that extension was granted till January 26th.
Yeah, but when would you do? That's what I'm trying to see, because
January 26th.
I sent them out. I sent it out, Your Honor, on December 8th.
December 8th. Okay, so
December 8th. Would have been, she requested an extension that I granted.
Generally, it would have been due sometime in January, like January 7th or so.
And
they gave her about 19 more days.
I gave her to the end of the month. She requested more time to respond. I gave her more time.
Okay, and you gave her
via email.
Okay, but at that time she did not have counsel.
That is correct, Your Honor.
Okay, and you gave her till the 26th. At some point, though, where's that letter? Are you writing that letter to her or to Mr.?
No, this is with counsel.
At this point, on the 26th, you recognize she now has counsel.
No, I didn't know. On January,
We filed a notice
whenever
of
they filed
appearance.
their entry is when I knew she had counsel. My communication with counsel was in response to their response to discovery was basically, in my mind, bogus. So I then wrote my dispute letter.
I know, but
January 30th.
I'm trying to get the date, so just kind of help me.
Oh.
Go back to your letter.
Okay.
You sent.
My good faith dispute letter?
Yes.
Okay.
What's the date on that, and who's that addressed?
January 30th, I addressed it to Attorney Simpson.
Okay. That January 30th. So by that time, because I think he came in the case on the 6th, right?
No, I came into the case on the 25th.
But you came in the case on the 25th.
Correct, Your Honor. I believe it's the 25th or the 24th, but yes.
All right. And so basically, from your perspective, you got 1 day to respond.
Exactly.
Okay, but Mr. Jones has already extended time for Miss Wynn.
That's
Right.
correct, Your Honor. Yes, yes. Miss Wynn has the extension of time. Counsel,
Okay.
we as counsel did not have much benefit of that extension of time. But
Right.
yes, you're accurate.
Right. And when you come in, you recognize, because I'm assuming she tells you, here's a letter, I got until the 26th.
Exactly.
When you get that letter and you know she has until the 26th, and I'm assuming your position is we can't make the 26th, what do you do?
We file responses that contain objections so that we can preserve our objections, because we did believe that a lot of the requests were objectionable. They were overbroad, they were unduly burdensome, they weren't relevant to the
And you filed that
on the 26th.
on the 26th.
That's correct.
Do you talk with Mr. Jones on the 26th and say, we just came in, we're going to file these objections because we need a minute to review them because we came in, and we're gonna supplement momentarily?
I don't recall whether we did that, Your Honor. I'd have to go back and look, but I honestly right now do not recall.
All right. So you filed it on the 26th, Mr. Jones, you read them, and then what do you do, Mr. Jones, after you
On
realize?
the 30th, I sent the notice of objection, which in this motion contains their answer. So it was these answers are not adequate, and I gave them until February 12th to respond.
All right. And so then you send your letter to them on 1/30, basically saying, I have reviewed your responses. I gave you to the 26th. The responses you gave are not proper. I'm going to give you now until
February 12th.
February 12th. All right. And then what happened after your letter?
Nothing.
All right. Nothing happens. And then you file your motion when?
I filed the motion to compel.
On the 16th, I see. Motion to
Right,
compel.
on the 16th of February.
All right. Mr. Simpson indicates that at some point they did after making the objections, they then supplement, clean some things up, and send you about 200 pages of documents. When did that occur?
Well, here's the thing. It's they provided discovery responses. Let me check the date.
March 14th, Your Honor.
Oh, March 14th? That's a whole month later.
Yes,
Yeah.
it was, you know.
Okay. Attorney's fees in the amount of $1,500. Can you prepare an order to that effect, Mr. Jones?
I sure will, Your Honor.
All right. Thank you. Anything else?
That's it for the pending motion, Your Honor.
All right. Thank you very much. So, Mr. Simpson, when can I get that order from you, and when can I get the one from you, Mr. Jones?
I can get the order to you by tomorrow.
You understand Mr. Jones asked for a finding of facts, conclusions of law?
Correct. I understand. I understand that. Yes.
All right. And you understand the court's analysis?
Yes. Yes, Your Honor.
All right. Thank you. Thank you so much, Mr. Jones. When can I get it?
I can get, this is going to be real short. I can get this to you tomorrow.
All right.
By close of business. Send it to the law clerk?
Yes. Ms. Harris.
Okay. Thank you.
Thanks so much. Y'all are both free to leave.
All right.
Thank you.